everybody to the second series of LegalTech Talks. Now, we've started slightly earlier, and I'm absolutely delighted actually to carry on the sort of fantastic initiative of what LegalTech Talks is, which is really delivering instant access to educational and challenging content, which is slightly controversial, but delivers informed opinions about what is happening surrounding us right now, what's happening in the legal market, and more importantly, intelligent insights from our thought leaders in the legal and commercial worlds. Now, today, following on from Professor Richard Susskind, I'm absolutely thrilled to welcome Mark Beer. Now, many people would have seen Mark Beer with us at the British Legal Technology Forum. So for us, we are absolutely delighted to have him with us for the LegalTech Talks series. Now, he's going to be discussing today law and justice in the COVID-22 world. And many will know he's also the co-founder of the University of Oxford's Deep Technology Deep Dispute Resolution Lab. And what I want to do is I'm going to pass it through to him shortly, but should any of you have any questions as we go, please either raise your hand and we will then ask those questions live, and Mark will be able to interact with you and be able to answer your questions. Or if you don't want to ask it live, put it into the Q&A below or through the chat, which we are monitoring. So coming at the end of his session, what we'll do is we'll start that kind of interactive debate. And I truly look forward to hearing everybody's thoughts. Mark, over to you.
Great, thank you very much, Francis. And it's a pleasure to be here. I do hope that this finds everybody safe and well during an extraordinary time. And I wanted to touch in a sense on this time and what implications it will have for the legal sector and the justice sector, because it was told to me many years ago that the Chinese have a curse, which is may we live in interesting times. And certainly the interesting times we live in at the moment do seem to be a curse. Today is St. George's Day. St. George is the patron saint of England, also Ethiopia, also Russia, Bulgaria, Portugal. Many countries have St. George as a patron saint. It was only the English, I think, that came up with the story about St. George and the dragon, but really St. George was sainted because he refused to give up his belief. He would rather die than to change his beliefs. And I think before this crisis, many lawyers felt that way about technology, certainly many judges, that their belief in the way that the legal system and that the justice should be delivered, they would rather die than see it change and reform to any great extent. And it made me think of the quote by the British Prime Minister, Lord Salisbury, who said, change, why change? Aren't we in enough trouble already? And there is a sense from many that during a crisis, it's the worst time to look at change and to implement change. You know, we're in enough trouble already, so why look to change? I don't subscribe to that, but I think that there are some that do. So what I want to explore in this talk is, do we think that the change that we're experiencing at the moment is sustainable? Will it stick? Is it ingrained now? Are Zoom conferences the future of conferences? Will life AC be different to life BC, before COVID? And what will be the drivers for change? What will accelerate the rate of change and what will decelerate the rate of change? And I want to look at 5 particular elements. The first element I want to look at is the type of work. Will the type of work between now and 2022 change significantly for law firms and barristers' chambers and arbitration centres and courts? The second one is the style of work. Will the way in which we work, particularly as lawyers, differ? The third is, will there be a shift in power towards the in-house teams? And that connects with fourthly, does that mean that law firms and barristers' chambers and to some extent arbitration centres and courts will become disintermediated from their clients? And lastly, I want to talk about legal education and the significant role that has in keeping lawyers relevant and to avoid that disintermediation. So let's start with whether there will be change. And many people refer back to the crisis of 2008 and 2009 to highlight the fact that change in the legal sector and the justice sector doesn't necessarily come out of deep-rooted seismic problems and crisis. And why would it be different now? Well, I think there's three reasons why it's different now. The first reason is that the crisis in 2008 and 2009, and I was in the midst of it, I had to set up within 10 days, a restructuring tribunal to look at the debts of Dubai World. But the crisis there was largely a financial crisis. It spoke to the financial sector and it led to enormous innovation around fintech. This crisis is different. This is a more deep-rooted. It's an economic crisis. Its breadth and its depth is much greater. It talks to the entire community. It talks to all businesses. And that's why I think the solutions that come out of it and the response to it will be broader too. I think technology will benefit, and I think that legal technology particularly. I think secondly, technology is now more advanced than it was back then, from digital doorbells and Alexa to the Sycamore processor, which can now process in 200 seconds what would previously have taken a supercomputer 10,000 years. We're seeing much more adoption. There's much more ubiquity around the way in which technology is being used by large organizations. And I think we're seeing AI judgment writing, AI contract drafting, and AI contract review all coming up to standards that are as good or better than the ability of humans. So I think technology is at a very different phase now. And I think even the decentralized law firm model, which didn't exist back then or to any large extent, has now become embedded and almost mainstream. So a lot of technology and a lot of law firm modeling has been waiting in the wings for its moment to shine, and I think that's now. And I think the third reason it's different today than 2008 is client expectations are very different. I think clients are more demanding, and I think they have every right to be more demanding because their fees have gone up significantly. And I think that they've moved away from looking for legal advice to looking for solutions. They have a problem and they want it fixed. They have an opportunity and they want a firm to help them deliver on that opportunity. And I also think loyalty is less. I don't think the idea that organization A has always been associated with law firm B lives on anymore. I think that in-house teams like to pick and choose more. I think they like to have different firms for different sectors. I think they like to have different people for different problems. So I think that idea that the law firm and client relationship is the same, that's also changed. Clients are looking for something else. And I think for those three reasons, the genie is out of the bottle. Now, you know, the naysayers would say that Pandora's box has been opened, but much the same effect, that I think it's going to be very difficult to put back what we've experienced as a result of this crisis. But what will be the accelerators of change? Well, I think for the private sector, it's going to be money. It's going to be the filthy lucre. It's going to be whether fees rise, stay the same, or fall. If we see a material drop-off in fees, I think we'll see an accelerated rollout of change in the way that the private sector, the law firms and barristers chambers, and to some extent arbitration centres, deliver, the way that they adapt to change. If fees stay the same or go up as a result of the crisis, then I suspect there'll be less incentive for that change to accelerate. I think that will decelerate the rate of change. I think for courts, particularly, it's not going to be driven by money. Yes, the economy may mean that many have got a little bit less in the kitty. But I think the motivator for courts to change is twofold. One is that they need to stay relevant. They're a critical part of society. And at the moment around the world, only 5% of serious legal issues actually find their way to court. 95% of them don't. So they're already less relevant than they'd like to be. And will that be further deteriorated as a result of what's happening? And I think the answer to that will be to what extent the private sector disintermediates the courts, to what extent private dispute resolution steps up, whether it's formal ADR, mediation, or, as I suspect, online. So, as I say, I think for the private sector, the drop in fees will accelerate change. I think for the court system, I think disintermediation will play an important role on whether they adapt. Turning now to the types of work, well, I don't think we would be in any disagreement that insolvency and restructuring is likely to stay high on the agenda, certainly for the next few years. I think sadly, family and probate is likely to see a rise. Healthcare, almost certainly that's going to do well. Healthcare lawyers will be in high demand. Overall, I think mergers and acquisitions are going to be under pressure, not least because cash is going to be king. Organizations will want to keep hold of cash. I can see some fire sales where good organizations with not a lot of money will be sold cheap to organizations with lots of money. I can also see a lot of activity along China's Belt and Road, particularly around Central Asia, where China continues to invest its war chest of cash to acquire, let's say at the moment, undervalued assets. So M&A activity is significant in Central Asia, and to some extent, I think bolstered for fire sales, but otherwise I think declining. And for disputes, well, certainly there'll be some hotspots. You know, there's a lot of work at the moment on force majeure, on frustration, on material adverse change contracts, but I think it is going to be hotspots. I think overall litigation fees will decline, certainly over the next 2 years. Why? Cash flows. Organizations want to hold on to cash, and litigation and arbitration is really expensive. It really soaks up cash. And I think, you know, CFOs are going to be asking their general counsel, can you delay this dispute for a little bit whilst we can retain cash? And is there any other way that we can fund this other than balance sheet? So I think the big winners when it comes to this crisis are going to be litigation funders and arbitration funders. I think they are front and center in able to support companies to continue to resolve large-scale disputes. Of those litigation funds, I think the obvious ones that will succeed more than others are ones that are data-led. So they've got large data pools and they use data and modeling to predict outcomes. They'll probably do better than the traditional approach of asking, say, for counsel's opinion on success. So if you look at funders like Augusta, which I don't think have a lawyer involved in its setup group, I think they're all financiers and data analysts. I suspect that those type of funding approaches will do much better. I think the niche funders, the ones that look at a particular segment or a particular geography, like Leonin Capital out in the Middle East, focus specifically on that geography. I think they'll do much better than funders that don't adapt. I think funders that use AI to review the due diligence materials, they'll do really well because due diligence soaks up so much time of a funder. And I think that settlement will be key for the funder relationship because the client wants settlement. The client wants the problem to go away or wants the money as soon as possible. And I think that's what will bring the funders into conflict with the law firms. Traditionally, funders have received instructions from law firms, but the incentive of a law firm may not always be aligned with the settlement incentive of the funder and the client. And that's why I think we'll see funding disintermediation, that is funders dealing directly with clients and then approaching lawyers, and not the client dealing with the lawyer and the lawyer approaching the funder. I think that divergence will lead to disintermediation. And I also think that at this time, clients are looking for something different. You know, there's that saying that to a hammer, every problem looks like a nail. And I think clients realize that the traditional law firm approach, where you take them a problem and they hit it hard with a hammer, that's not going to be a winning strategy going forward. They want organizations that bring a broader portfolio, a broader toolbox. They must have a hammer in it, but it also needs a very fine scalpel and other tools in order to achieve the client's objectives. So the big four, they bring a multidisciplinary approach to problem solving, organizational wide. I think they'll do really well. And I think the intermediaries like Emissary Holdings, which bring a more holistic approach to problem solving, will probably again look to step in and disintermediate the law firms with their singular hammer-like approach to dealing with problems. But overall, I predict that fee loads are going to decline over the next 2 years. I think that we're going to see law firms close or as they say, merge. I think we've already seen a well-known London barristers chamber shut up shop. I think we'll see arbitration centres fail. I think it's going to be a horrible, horrible time for the sector, and for all those affected, I feel deeply sorry. I think to survive, though, what's needed right now is greater agility, greater efficiency, a focus on remote working for efficiency's sake and for staff happiness, and a much greater focus on technology. And I do need to say that throughout this talk, I'll refer to organizations that I'm familiar with. Some I'm familiar with because I've worked with them, others I'm just familiar with from research, but I'm not endorsing any organization in this presentation. If we look now at the changes to the way we work, I think it's fair to say that you know, working from home is becoming more and more, for most people, more and more an option. that fear that we can't collaborate online is going away. And if we look at the augmented reality tools that are coming onto the market now, with goggles on, we can really be in any room, anywhere in the world, and believe we're with others from the comfort of our own home. I think there was the famous story about the law firm that launched their Office of the Future. And I think someone put on their press release that the Office of the Future won't involve having an office. And I think there's some truth in that. And I think law firms will be motivated to support working from home, mostly from a cost point of view. But I think it'll be sold as an employee benefit and an employee perk. And frankly, both work just as well. The question comes, should the law firm then compensate the lawyer for the space that they use up in their house? Should it contribute towards their rent or mortgage? Well, I think that's going to be an interesting one, and probably one that will find its way through the employment tribunals. I think there's been a sense that legal technology adoption has been difficult and slow, and that lawyers haven't been very good, but that's not been the case. I think we've seen Zoom grow from 10 million users pre-COVID to 200 million in a fairly sustainable way. I think we're now getting more used to conferences online. So in terms of the way that we work, and working from home and the like, who are going to be the big winners? I think it's obvious. I think it's the decentralized law firms. I think it's the distributed law firms, the Axioms, the Keystones, the global legal solutions. They're already ready for that post-COVID world. They're already ready for a decentralized solution. I think they're going to be ahead of the curve. I think they'll do well in the next few years. But I think the biggest change, and perhaps more interesting, is why should a lawyer only have one employer? Traditionally, you know, we're recruited by a law firm and we work diligently for them, and we work our way up through the ranks, and eventually we come out at the top, and we you know, that's the way that we've done it, right? But why? If we're looking at decentralized provision of legal services, why can't a lawyer have 2 employers or 3 employers? Why can't the lawyer be available to consult to in-house teams and part of their team, and to 2 or 3 law firms that need their skills? So are we moving towards a world in which a lawyer, an employee, can have more than one employer? I think that we will, and I'll talk a bit more about that when we come on to disintermediation. The next element I wanted to cover was shift of power. I really believe that the in-house team is going to take considerable power within its organization and over its purchase of legal services. I think that's because they're going to take on more accountability for risk management, particularly contractual risk management. I think organizations will want the legal team to be able to have at their fingertips information about the rights that the organization has worldwide and the implications of change, the commitments and how those commitments vary if they're modeled across different scenarios in different markets. Real-time enforcement changes that may happen that may make a particular contract more or less enforceable. The creditworthiness of counterparties in real time. To what extent does pricing vary based on creditworthiness? The entitlements of the business globally based on their contract network. These are all going to be really important factors at the legal team to deliver. And they don't lend themselves to a traditional law firm relationship where you send a contract and you ask whether it's enforceable in Egypt, and then if anything's changed and you get a report, and you know that speed is not something that the business wants. They want to know at the click of a finger what their risk exposure is from a commercial point of view, and the legal teams will be at the fore of that. It's certainly the case that in-house teams I talk to don't want legal advice anymore. They want solutions. They don't even talk about legal solutions. They want solutions. They go out with a problem. They want someone to help them fix it. And therefore, I think the big winners in all of this are going to be the big 4 accountancy firms. They've been the gentle giants to some extent in the background. But the fact that they've already got a multidisciplinary approach to customer service, the fact that they are focused on broad solutions, the fact that they've got sophisticated organizational risk modeling that law firms in the main don't have, the fact that they've been implementing technology way in advance of most law firms, the fact that they're multi-jurisdictional, the fact that they've got scale, all of these make me think that the big 4 is going to come out of this crisis really battling with the top end of the legal sector for work, and I think it will do incredibly well. I think also for general counsel and for in-house teams, why go for one firm? You know, I'm often amazed that if there's a particular issue, an in-house team will appoint a firm to handle the whole issue, when what they would probably do if they were recruiting internally is to source people from multitudes of firms that they think could coalesce and work best together. And I think we will move towards a model where legal teams are going to be asking for individual lawyers with particular skills and background to support a particular initiative from multiple firms. And I think the firms that encourage that, the decentralized firms that encourage that, that allow for that, will do really well. But the firms that retain that view that, no, it's my lawyer, it's my team, it's my billing, it's my system that the client has to plug into, they're going to lose. I view it as a move from what we'll call the ecosystem. You know, I am this firm and I am the best and my lawyers are the best. An ecosystem to an ecosystem where law firms and lawyers collaborate around client platforms, not around their own platforms. So I see this big shift in the power of the in-house team to dictate how they're going to get service and what service they want. And that leads me to talk about disintermediation as the gap between the expectations of the client and what the client wants, and the ability of law firms and barristers' chambers and courts and arbitration centres to deliver that expectation, as that gap widens. And I think this crisis has accelerated the way in which it's widening. Then I suspect that others will come and fill the gap. It's the nature of the market. I think that we've already spoken about the litigation and arbitration funding, and how I think that's going to move from them drinking from the hose pipe of the law firms to moving and working directly with the client to talk about problem solving, taking the problem off balance sheet, appointing the right law firms, and so on and so forth. I think that's, if it's not happening already, it soon will. And that pushes the law firm away and out of control of the situation. And many would say that's good, others would say that's worrying. We've spoken about the disintermediation of the big four, the fact that they can likely come in with a more solution-orientated and holistic package, and organizations like MS3 Holding that do the same, that could come in and advise, with legal being one facet, but advise more broadly about how to achieve a goal or solve a problem. We've spoken about how I think the decentralized and distributed law firms like Axiom and Global Legal Solutions and Keystone and many others are going to be coming out of this far better than the traditional firms with the large office overhead and the large equity partner overhead, and without a platform for distribution, although this crisis will have allowed them to speed up the rollout. So I'm not going to talk too much about those, we've covered them. But I am going to talk about technology disintermediation, and particularly, you know, we know automation. Automation is already starting to play a more important role in delivery of legal services. But let's, I'll tell you, I was demoed the other day. I had a demonstration by of an AI tool that sits in the core of a corporate legal team. And if you define, and it's AI, so you can define quite, you know, in natural language, if you define the parameters of your organization's contracting policy, what you will and won't accept, what risk is tolerable, the platform, any contract in the database or any contract that comes in for review goes into the technology, and the technology will tell you if it complies with your contracting parameters. And if it doesn't, it will show you where it is non-compliant. So from a review point of view, it takes away all contract review for large organizations, both historic and future. That's a huge disintermediator as a technology solution between the in-house legal team and the law firm. I think that we see contract builders now, AI contract builders, where you can start to build standardized contracts, and the technology will build them based on commercial terms that are put in. Organizations like Claros are working hard on that. That takes away a lot of drafting. We see smart contract work like Your or Jaw.io, where we're building standardized smart contracts which de-risk the contract. They remove the concerns about privity. They enhance enforcement. They enhance efficiency. They enhance centralization and the power to control. They do away with the need in large case to constantly review performance. The contract is self-reviewing and self-performing. So we're going to see, I think, at least 50% of international contracts within 10 years will be smart contracts. And in terms of disputes, as I say, 95% of serious legal issues do not go to court. That's 95% in the sense of trying to find another home. It's not that they all go to arbitration either. Many are just left. People don't do anything with them. They hope that they go away. It leads to terrible problems in society. People get sick of worry. Businesses close. I mean, it's awful. I mean, every day on average, a small to medium enterprise in the UK spends an hour and a half chasing overdue debt. So these type of issues which don't go to court are quite significant. And so who's going to fill the gap? Well, the obvious ones are disputes, online disputes platforms. We saw them originally with People Claim, but I think now organisations like Resolve Disputes Online out of Australia are starting to embed that solution. And I looked up on their website, their mantra. It says, making justice effortless and accessible, which I think is a wonderful sort of ambition for an online platform. And I think we'll see significant disintermediation there. And I think more worrying for all of us is the work being done in laboratories, technology laboratories all around the world, which are looking at how, including, you know, we've got one here in Oxford, the Deep Tech Lab that Francis mentioned at the beginning. But looking at ways in which we can analyze huge amounts of data to predict disputes way before they become disputes. So the predictive tools based on big data, which will allow organizations to avoid disputes altogether well in advance of them sort of escalating up. Now that really is a disintermediator, fantastic for the client, absolutely awful, if you will, for the sector. You know, I don't see that we're a million miles away from that, but another example of how disintermediation could significantly impact the sector. And I'll finish in terms of the 5 elements on education, because I ask myself, how many lawyers know how to draft a smart contract? And how many lawyers know how to amend a smart contract? And how many lawyers know how to read a smart contract? How many courts and arbitration centres have thought about enforcement on the blockchain or to amend a smart contract? How many think in a decentralized world? You know, how many think about whether what they do works in a decentralized world? Who has jurisdiction over a smart contract operating on 2,000 nodes across 100 countries? You know, you can change one node. The courts can issue an order to change one node, but you need 50% of all the nodes to change the contract. And there just isn't that level of connectivity. So who's thinking about these issues and who's teaching the lawyers of the future about them? I think we've seen some really impressive work and thinking out of City University's law school, no question. I think some great work from Professor Rosanna in Leicester, but not many law schools are really thinking about how to embed technology and the things we've been talking about across the course. And therefore, we're producing lawyers today, as we've produced lawyers for many years, who are articulate and bright and brilliant and able and capable and can review well and can précis well. But they're not really ready for the future that I've been describing, a disintermediated, solution-orientated future in a law firm which is decentralized. And I think that has to change. If it doesn't change, then sadly, the rate of failure and the rate of disintermediation will increase significantly. But if we can educate lawyers better, if we can educate judges better, if we can educate arbitrators and mediators and those that work in these institutions better to be ready for a new world, then the gap between the expectations of the client and the expectations of the legal sector will at least perhaps hold where they are. So in summary, I think change is here to stay. I don't think this is like 2008 and 2009. I think this is too deep-rooted in terms of a change in the profession. I think money will be the accelerator. So I think, if I'm right, a declining fees across the legal sector will drive reform. I think this move from what I call the Garfield way of running a law firm to the Darwinian way, the movement in terms of legal law firm management from the Garfield principle, which is survival of the fattest, to the Darwinian principle, survival of the fittest. I think we'll definitely see that, and I think that's going to be good for the sector, but there will be sadly many that fall away by the wayside. I think the big winners in this are going to be the litigation and arbitration funders. Their interests align exactly with the interests of the client in a way that law firms have, it's been alleged, not historically done so well. I think the distributed law firms are going to do really well. They're already set up for a post-COVID world. And heaven forbid, if we did see COVID again come back in a couple of years, they're ready and able to be able to continue to serve their clients as a result. I think legal technology that fills the gap, the big gap, the divide, technology that comes in and disrupts, it will do really well, whether that's the work that we're seeing with dispute resolution or elsewhere. And I think that in-house teams, the power and the control and the influence of in-house teams within their organization and their ability to control the way in which they get real-time data to best analyze risk, those are all going to be important and will rise. The big losers, I think, will be the very large firms with expensive commercial real estate overheads, very expensive networks, very expensive equity partners that aren't necessarily delivering significant value or as much value as they might. Those are the firms that the Titanics, if you will, or the VLCCs, that there's very large ships that take a long time to turn. I think the big four will eat the top end of the market. And I think lower down, we'll see firms that have been working on technology like Mishcons and the lab that they've been running for some years now. They're hungry and they're ready and they're agile to take work from clients that the more stable, let's say, firms give up because they can't adapt fast enough. And that means I do think we're going to see significant disintermediation between now and 2022. I think it'll be palpable, and I think it will drive down fees to law firms, which again would accelerate the rate of change. I think that's a positive thing in many respects, but I think it's also something that we need to be cautious about, we need to manage, and we need to be aware of. We keep an eye on it. Private sector disintermediation of justice may bring efficiency, but there are still some question marks over whether that's the right thing for a society. And can we expect courts and to some extent arbitration centres to keep up with the private sector? Should they partner? You know, HMCTS is doing an incredible job, and some of the work out in AIFC in Astana is really cutting edge, but not many court systems are operating at that standard. And lastly, I think we need a very different type of legal education. I think if lawyers are really going to deliver to the community that they wish to serve, if they're really going to stay relevant, if they're really going to be able to help the community and society as a whole, we need to educate them and educate them to be future lawyers, not necessarily educate them to be good at either yesterday or today. So I hope that was interesting. I hope it was helpful, and I'm very happy to take questions.
Thank you, Mark. So everybody, so obviously if you've got questions following Mark's discussion on certain aspects, I know I've got a couple myself, please do put them through. So if you've got, if you're listening in via your laptop or PC or the phone, please put your hand up and we will be able to bring you in live. Mark, so we have, if we start some of the questions, we've got one question from Michael, which we will answer live, Michael. So Michael Magda, can AI predict the outcome of cases? And if yes, what types of cases have a higher chance of an accurate prediction? Mark, over to you.
Well, Michael, thank you for that. And the answer is yes, and with a worrying degree of accuracy. Now, the scientific tests have been used on a narrow set of cases. But there's no question that if predictive models are best based on very large data sets, then for litigation, for court processes, the ability for technology to analyze tens of thousands of judgments from different varieties, to weight them based on the judge, on the relationship of the judge to other judges, on the words that a judge likes to use, on all manner of parameters, it would mean not only do I think AI can produce a highly predictive outcome, certainly with greater certainty than a single lawyer looking at a set of papers and with the knowledge of a jurisdiction. But I also think that the ability of that technology to review all paperwork affiliated with a particular issue is going to mean that due diligence and clients paying for due diligence in order to assess a case is going to fall away as well. Now, that's all, I think, predicated on jurisdictions not closing down. So in France, it is a criminal offence to analyse and try and predict data based on the justice sector. Some people think that's important because judges should not feel threatened that they have to constantly look over their shoulder. But I think many view that open source justice and the ability to review in order to assess is something important. And if that's the case, then yes, AI is going to be far better at predicting outcomes generally than certainly an individual lawyer, I suspect. Now, that's not to say that I think that AI, robots are not going to replace lawyers and judges, certainly in our lifetime. But I think that firms and lawyers that embrace AI will replace firms and lawyers that don't, because clients will stop paying for human review that can be better done by a computer. And the Law Geeks review, where they gave a set of lawyers some documents to review, and they gave the same set of documents to a computer, and the lawyers took on average, I don't have the exact data in front of me, but I think it was to review 19 documents, it took them, on average, say 80 minutes, and they got a 75% accuracy. And a single piece of software reviewed the same documents, it got a 92% accuracy, and did it in 17 seconds. Now, I've sort of made those numbers up, but they illustrate the point that technology is already there to be able to use AI to not only review documents, to predict outcomes.
Thank you, Mark. We're getting quite a fair few questions, so we're going to try through. So there is one from Abdul Muzadik. Now, he asks, does Mark think learning how to code should be part of modern legal education? And if not, what specific skills are becoming more important for aspiring lawyers? Good question. Over to you.
Brilliant question. And it always reminds me of the, when I mentioned about technology in legal education, people would say, well, do you think that a construction lawyer needs to know how to lay bricks? Well, the answer is no. I don't think they need to know how to lay bricks. But if they do know how to lay bricks, they're far more likely to be helpful in a construction dispute, right? Because the client needs somebody who knows what's going on. So should lawyers learn to code? It's not a necessity. Of course, it's not a necessity. We've got technology now that can translate smart contracts into human language, so to speak, and vice versa. And we're seeing building blocks like Jules' building blocks and Claros' building blocks, where lawyers can build their own contracts. But it would definitely help to have an understanding of code when it comes to reviewing smart contracts, because if you think about a dispute over a smart contract, there are two issues. The first issue is who's to blame, right? Did the coder misunderstand the instructions? Did what went wrong, and who's to blame? And did anything go wrong? Is the code wrong? Is it the coder that was negligent, or is the code reflective of what they were told? So some element of understanding coding is going to be really important. I think the other element is the enforcement side of it, because so you can demonstrate that there's liability, and you've then got to find somebody who can issue you a decision. And then you've got to know how to get that decision to be operating and to adjust the smart contract. So I think a broader element around smart contracting technology is going to be vital. But as I say, the critical part of it, in my view, isn't that we teach technology and legal technology as one facet of a syllabus. We need to instill technology throughout every course. Now, I don't know how it would apply to Roman law. I understand that. But when it comes to contracting, when it comes to tort, when it comes to some extent criminal and evidence, blockchain-based evidence, there should be elements of technology that spread across. But if there was one skill that lawyers will need, perhaps more than ever, in a world that's ever greater in terms of disintermediation and the power of technology, it's going to be relationships. What makes an organization choose lawyer A over lawyer B to join the team will be based to some extent on experience. But to some extent, it'll be, do we want this person, working with us? Didn't Google have a recruitment thing where it said, would you want to spend a few hours with them in an airport lounge on a delayed layover? That was the test. And I think lawyers that are, who understand that and they're taught about empathy and emotional intelligence and understanding, and thinking outside the box and being creative, that's probably the best skill we can give lawyers over and above the traditional legal education and a focus on technology.
Thank you, Mark. Now we're getting more questions, so hopefully we'll be able to get through them all. So thank you, everyone. So this is from, so for the next one, if you're prepared, Mark. So Peter Petit, he has asked, Mark, do you agree that that the COVID-19 crisis is an unfortunate catalyst for the introduction, acceptance and use of technology in international arbitrations, and that this should result in a reduced cost of running arbitrations, which will in turn make the economics of running those claims, whether funded or not, more viable?
Yes, I think that's absolutely right. I think, was it Peter, did you say, Francis?
Yes. Yeah, I
think Peter's got that is absolutely right. That's what's going to happen, you see. I think this need to jump on a plane all the time to sit in a meeting to try and lock in the time to meet an arbitrator that's busy because they need to fly somewhere. I think those days they're long behind us, and what that means is a more efficient arbitration process and the litigation process. It's not just limited to arbitration. I think that AI-based tools to help a client understand their position before they get involved in serious dispute resolution like arbitration litigation, that will help. I think predictive modeling, so both sides have roughly the same idea about how likely they are to win, will lead to greater settlement, and that will also help the process. I really do think, and your phrase, Peter, was fantastic. It's an unfortunate byproduct of this crisis, or rather this crisis is an unfortunate situation which will lead to changes which I believe will be seismic, but better overall for the clients. I think, though, the risk is the damage that they will have to the legal sector as a whole.
Thank you, Mark, for the answer there, and hopefully that's answered your question, Peter. We have more questions, but the next one is from Danushka de Soiza. I do apologise if I got your surname wrong. Now, the question is, traditional contractual disputes will seldom require expert evidence to certify the actual execution of agreements, whereas in the case of smart contracts, expert evidence may be required for the interpretation of code. This could add unnecessary expense and time to litigation. What are some current mitigation strategies to overcome this issue? Interesting question.
It's part of this.
They're testing you.
Yeah, well, and the answer is that smart contracts don't stop. So the inefficiency of the traditional contracting model, particularly if one party isn't let's say a fair actor, is that either party can influence or corrupt or adjust the contracting process, which leads to the dispute, which, as you quite rightly say, doesn't need an expert. Now, of course, some disputes do. If somebody alleges that the quality of products delivered under the contract wasn't good enough, then quite often you will see an expert in that. If it's but for a traditional contract dispute, let's say a debt issue, then you don't need an expert, right? You can prove that the debt wasn't paid and that the contract had been fulfilled. However, in a smart contract, there's no need for that because one actor cannot stop the contract being self-executing. So as an example, if you take a supply chain, if a car company in Germany has a 150 layer supply chain and it ends in a bauxite mine in I don't know, pick a country, Turkmenistan. The traditional model with privity was that money sort of flows down that chain and eventually gets to the bauxite mine. But in the smart contracting model, the smart contract, as soon as the bauxite is delivered to the smelter in Kazakhstan, as soon as the smelter says, yes, I've received it, the bauxite mine is paid. If it arrives late, a day late, the contract itself identifies it's a day's late, imposes a penalty on the payment to the bauxite mine, and then incents the rest of the supply chain to speed up by 1 day. It shares the penalty out, and anybody who can speed up a day will then benefit. No lawyer involved. And there's no ability for the German car company to not pay because the contract will transfer payment immediately upon the the bauxite being certified by the smelter. So you take away a lot of those contractual issues that don't require an expert, and you simply move them into a world where the contract does it all. But to your point, what gets fascinating then is what happens if the contract gets it wrong. And I think the answer to that is the world needs some more oracles. That's the phrase. Oracles can be AI driven. So if you look at force majeure weather events, the contract can just look at the weather forecast and tell you if there was a force majeure weather event. Or they can be human oracles, where the contract says, you know, there seems to be a problem, something's not right, this is a situation I haven't come across before, and it spits it out to a human panel who then determine the outcome, and they have authority to recode their smart contract. That again just often will avoid lawyers, avoid courts and arbitration centres. So it's a long-winded way of saying you're absolutely right, the smart contract disputes will be a lot more complicated if they go to court or arbitration, but the vast majority will never get there because the contract is designed to perform itself.
So interesting questions just being fired through against our good friend Suskind, actually, via chat. So I thought I'd bring that in. This is from Justin Smale. So thank you very much. Do you believe predictive AI models are close to explainable reasoning? Suskind's decisions with reasons.
Yes, I think they are. I mean, we're a long way away from artificial general intelligence, and I think that's what Richard in his quite brilliant new book, with which I agree entirely, is talking towards. I mean, the Chinese have got now a judgment drafting piece of technology that they use in Shanghai and Beijing, where you upload the entire court file into a system, including videos and photos and documents and everything that you can. And it will draft a judgment which sets out relevant law, relevant precedents, which is interesting because China doesn't have that sort of precedent system, but relevant precedent for the judge to look at, and then it will have a go at the judgment. Now, all the judges tell me that it's not very good, and they may well say that, but at least it's sort of 20% there, leaving the judge only 80% of the work to do rather than 100. So I think we are getting to the point where we're moving towards a world in which the AGI model is going to be there. And I think the intermediary position is known as XAI, explainable AI. I think we're much closer to that. That is, the challenge with AI is when it gives you a decision, it's not always clear why you got there. It's like the the computer in the link. It's like the planet Earth and the Hitchhiker's Guide to the Galaxy. You know, what's the answer to life, the question of life, the universe and everything, and the computer says, well, it's 42. That's really useful. But what of course we don't know is how it got to it. And if you remember in the Hitchhiker's Guide to the Galaxy, the computer said, well, I'm not smart enough to tell you that. You'll have to build an even bigger computer. And explainable AI is helpful because if it writes a judgment in a certain way, it'll explain why it's done it, and then it can learn when the human says, well, that wasn't quite right, or you went wrong at this point, like a mentoring program. And we are very close to having explainable AI help us in the legal sector. So I don't know if that was a direct answer, but I do agree with Richard that it's closer than we think.
Thank you, Mark. I have to admit, I love Hitchhiker's Guide to the Galaxy. So old school, yes, but brilliant film of that. Moving on to the next question. So thank you for all these questions coming through. So the next one's from Jeremy Kammer. Are the AI tools you reference, clever though they may be, likely to add, not decrease the cost of legal advice? The developers need a return on their capital investment. Good point. It's
a fantastic point. So let me take you to that global legal solutions technology that reviews contracts for an organization. I don't know the pricing of it, but say the pricing of it was $10,000 a year as a license fee. And say that $10,000 meant that you could review a contract history of, I don't know, 1 million contracts stored in a large-scale organization, scale it down even to, let's say, 10,000 contracts. So it can review 10,000 historic contracts for compliance with the organizational's parameters, risk and jurisdiction and all of that kind of thing. And anything that comes in, even if it's 1,000 pages, can just be run through that technology, and it'll tell you whether it's compliant or non-compliant with the organization's contracting policy. Now, if you send 1,000, I mean, let's even be realistic. If you send a 50-page document to a law firm and ask them to do a review and give you an analysis around factors like enforceability, around risk, around parameter review, how much is that going to cost you? $1,000. That's an hour of a partner's time at the current rates. That's how expensive lawyers can be nowadays. Even 2 hours of an associate's rate. So 2 hours, let's say, to review the contract and write a letter. So you don't need to have many contracts that need reviewing for that technology to pay for itself. And I think in all of this, I'm afraid that the technology is probably a tenth of the price I've quoted. So I think technology will significantly reduce the cost of doing legal work, if that disintermediation. But where it might be on the large scale disputes, the large scale disputes which are ongoing at the moment, which will trundle on. And that's why I think the litigation funding and arbitration funding will become enormously successful. It's already successful. I mean, someone described it as drinking from a hose pipe at the moment in terms of workflows. I think it's only going to get busier and busier because corporates want to get that cost off their balance sheet. So for law firms running the traditional model, the hourly rate model, the $30,000, $40,000 a month retainer for an arbitration, then the business will move to funding in order to be able to pay for it.
I hope that answers your question. The next one is from Marabella Metzler. She asks, do you personally know of a use case of smart contracts?
Oh, so many really good ones. So I'm a visiting professor. I'm a visiting fellow here at Oxford, but I'm also a visiting professor in Shanghai, to the Shanghai University of Political Science and Law. And what they do a lot of work on is de-risking the Belt and Road. That's this $7 trillion, well, numbers vary, but $7 trillion spending spree by the Chinese government across 40 or so countries around the world. And the realization there is if you rely on traditional contracting models, then you're going to end up in a court that you don't want to be with a decision that you can't enforce. So that move out of China now to define the standards of smart contracts is absolutely significant, really significant. And there's some great real life examples coming out of China of smart contracts. And then if you look at the stuff that's going on, as I mentioned, JUR or YOR, depending on how you want to pronounce it, JUR.io, and the work they're doing on smart contracts, Kleros on smart contracts, that ability now to develop standardized contract bases, it's there. And if we look at the major supply chains, many of them are now operating on a smart contract basis. But I think to your question, will we ever get to a decentralized smart contract network? Will we ever put our smart contract out on a decentralized network? Well, that's where brilliant academic thinkers who are normally right, like, her name's disappeared, a fantastic Harvard professor who's looking at this. She says, yes, we will move towards a decentralized smart contract network. My gut feel, having been general counsel for 72 countries for MasterCard, is we will never give up control. And if we can be the judge, jury, and executioner for the contract network, then we will. And therefore, we'll keep it in our node and under our control. And provided that's acceptable to the counterparty, and it will be, unfortunately, if it's a question of contracting power, then we probably won't see smart contracts as the world thought they would be, decentralized, multi-nodal contracts. We will see single node contracts with them being controlled by the organization. And I'll finish on this. The productivity boost of using smart contracts is around 2 to 3%. So it's 200 basis points. It doesn't sound significant. But if you've got a global supply chain, 200 basis points is actually a very nice saving to make for the cost of running a contract which doesn't really require much by way of legal input or human resource to monitor.
Thank you for that, Mark. We have a question coming from someone who's remaining anonymous on this one.
Oh dear, this could be a tough one then.
Well, it's slightly long, but I don't think it's tough. I think actually it's a very practical question, which is facing many within the profession who I know we work with. So the legal profession is sadly plagued by negative stereotypes. Often I've found that a means of mitigating said stereotypes is through simple interaction in person, especially on sensitive matters such as family, probate, and insolvency. This one-on-one interaction is imperative. In light of COVID-19, how do you see legal practitioners coping with this inability to interact traditionally? It's a very good question, because a lot of people need this.
Yeah, and there is no doubt, that's why I sort of said legal education, one important facet is going to be the humanity and making sure lawyers remember that they are helping people and that's their job at its core. So I agree with you in many situations, even in hard-nosed commercial negotiations. Actually, sitting and seeing and talking and exchanging is often better, and particularly in very challenging situations around probate and family. So that's absolutely right. The challenge of that model is it's not very scalable. You know, you can only travel so far. And what we're realizing during this crisis is that we can empathize with each other virtually using this dot matrix technology of a camera perched on our computer. But where I see it going, and particularly for law consultations and solution-orientated consultations, is going to be augmented reality. We will be able to sit here, and you all will have glasses in the same sort of standard way that we have these video cameras. And NetLaw, which pulls these sort of excellent events together, will create a room. It could be anywhere, it could be on a beach in the Seychelles, but they will create a room which all of us will see. And as we look around, we'll see each other and interact with each other in the way that we would if we were in person. We can sit where we want. When I was in China last time, I went to see Tencent, which has one of the biggest payment platforms and financial processes each day, more transactions than Amex, Visa and MasterCard all together, and they do it through a tech platform. And I said, what's your biggest revenue increase? They said, oh, football. So I said, well, I'm no expert, but football is not a digital platform. They said, oh, yes, yeah. Just people pay to watch football. So I said, yeah, I know, but how? That's like TV, right? You mean you TV? He said, no, it's virtual football. And what they meant was that a team of 11 humans will be sitting at home with AR goggles on, and they will look through the eyes of 11 virtual players on a pitch. And the other side will have 11 humans doing the same thing. And then, and this is the extraordinary thing, people pay to watch the game. And the reason they pay is they can do it from their living room. They can have AR goggles if they want, or they can just watch it on their screen. They can choose the seats. They can look through the eyes of the referee. They can be in the middle of the pitch. They can float above the pitch. They can follow a particular player. And I thought when I heard this, it was just an extraordinary sense of, this is the way the world's going. We're going to start living in these dream worlds which are created through an augmented reality, where we think that virtual football is just as good as physical football. And do you know, for those that don't like football, it may well be. I mean, they may be even better because you can choose your seat. But I think when it comes to that human nature, when we move into an augmented reality world, we will be able to engage one-on-one or to a group using these glasses. And it won't take more than a few seconds for our brain to actually think that we're with them. And when we reach out, the only difference will be that when we go to touch them, our hands will go through that image. So I totally agree with your point of view that the humanity is going to remain critical, but I think the way that we interact is going to change.
Thank you, Mark. I wanted to bring up about blockchain, if I can. You talked about blockchain. Do you, Mark, see blockchain use accelerating in legal services due to current digital, I suppose due to the current digital climate, especially with the increased use? Look at the type of technology which has been implemented, now heightened because of COVID. Do you think that this is now going to give the push it needs?
So I think the answer is yes, but I'm cautious. And I'll tell you why I'm cautious. I'm not very popular for being cautious on this. I see blockchain a little bit like the dial-up we used to get when we first got a computer at home. You know, it's a bit clunky, it's very expensive, it's quite slow, it's not that efficient, it can only manage a certain number of transactions, people don't really understand it. It's really like the old dial-up. It's like those cassettes we used to put to download games, you know, in the ZX81, and I realize I probably lost half the audience here. But the blockchain concept is one of a thought process around cryptography and the use of hashes. And I think that ecosystem is definitely on the rise. It will be the platform on which we have smart contracts. It will be the platform on which we store asset records. It will be the platform where the land registry allows us to buy and sell property seamlessly without almost any cost and the push of a button. It will protect people's rights because it's unassailable. You know, in many countries in the world, when they're invaded, the first thing the army does after it blows up the communications network is it blows up the land registries, because once you destroy all that paper, no one owns anything. If you blow up a passport office, people lose their identity. And how in Syria are people expected to get a passport when everything's, you know, not as it should be? Whilst blockchain data would allow you, if your birth certificate was on the chain at the push of a button, you would be able to prove your identity. So there are a lot of uses for blockchain and let's say the new hash graph technology that comes out of it. And I do think that as we saw China, 3 years ago, say the blockchain evidence was valid evidence for the purposes of disputes, which was totally took us all by surprise because they'd been so critical of facilities like Bitcoin operating on blockchain. But they were the first court in the world to acknowledge blockchain evidence as being valid evidence. I think we'll see a lot of the standard setting coming out of China. So as standards for blockchain and new hash graph technologies grow, as standards for smart contracts get defined and they grow, then application will come more and more for the legal sector. But even if we look at a standard acquisition, you know, if anyone's ever had to sit in a 40-foot container or a warehouse going through data sets to look over, you know, historic title over assets, then imagine if those assets were simply, title was proven by their blockchain register on acquisition. It would make the transaction a whole lot more pleasant, certainly for the junior lawyers who are sent into the warehouse.
No, thank you very much for that, Mark, and thank you for everybody's listening. So that's our time, and I want to thank you very much, Mark, for your time with us and being able to join us and really discuss your views and put them across, and also for all the questions which we've received from everybody. So thank you very much for joining the LegalTech Talks series, and our next one will be on the 6th of May for the future of legal tech with a roundtable and debate. So Mark, I look forward, and thank you again. And everyone, great questions. So thank you.
Thank you very much. Thank you.